Okay, so you just wanted to watch. You can watch on YouTube. Go to the court's website, 36districtcourt.org, and you can, if you're just wanting to watch, you can just hit view via YouTube and you can watch.
Okay.
If you wanted to speak or talk to the people, you can talk to them and then let me know. But if you just wanted to watch, you can watch via YouTube.
Is it possible to talk to the people? Or no?
Mr. Vincent, Ms. Coyle,
Yeah, no problem. Who is it on?
it's on number 8. You want me to put you in a breakout room with her?
Yeah, I just want to make sure that it's mine.
It is. It's Love Wilkerson.
Yeah, go ahead, magistrate. Thank you.
Thank
So
you.
Reverend, that's the prosecutor. I'm gonna put you into a private breakout room and you two can speak and then we'll take it from there, okay?
All right, thank you, Your Honor.
Thank you, Mr. Vincent. You ready?
Yes, Judge, I'm ready for Mr. Abbott.
Good morning, good afternoon, sir. David Partridge?
David Kravitz, yeah.
Private.
Sorry, I'm a little underdressed. I didn't think that I'd be coming.
Thank you for that, no worries. Mr. Partridge, you're on case 23045-485. People say Commissioners David Joseph Previch. Parents for the people.
Good afternoon, Lisa Coyle appearing on behalf of the people.
Good afternoon.
Good afternoon, Judge Miguel Rico, P8879, here on behalf of Mr. President, who is in person today to my right. My client's been advised of constitutional rights. He waived the formal reading of the complaint. He stands to you, Judge, and requests that this court enter a not guilty plea on his behalf.
Thank you. Good afternoon, you both. For a waive formal reading under plea of not guilty, Mr. Previch, I'm scheduling a pretrial date via Zoom. You must attend on July the 7th, 8:30, 36th District Court, Judge Bryant. July 7th, that's on a Monday, understood?
Understood.
Not guilty, please enter on your behalf. Ms. Coyle Esteban.
Your Honor, this is an OWI 2 high BAC. This is back from March of 22. The last OWI was in 2019. The allegations that he fell asleep at the wheel at a drive-through. No objection to a 15,000 personal. His blood alcohol level was extremely high. It was a 0.268. And I will leave into the court's discretion as whether an alcohol tether is necessary. I always say that the fact that his 2019 wasn't that far ago, his blood alcohol level is extremely high, over 3 times the legal limit. Even though this case has some age, I would ask for that alcohol tether as well. And of course, no drinking during the pendency of this matter and no driving without a valid license. Thank you.
Thank you. Response.
But Judge, I would, on behalf of Mr. President, I would ask this court to adopt the recommendations of personal bond. We have no objection to no driving without a license. We have no objection to no alcohol. On Mr. President's behalf, in regards to an alcohol tether, I understand it is the norm in cases such as these to impose one. Judge, over 36 months have passed since this incident date. From that date until now, Mr. Previch has had no alcohol-related contact with the criminal justice system. He's indicated in my office that he's 3 years sober. From that date until now, that was the last time he had a drink. He only found out about this today because he was pulled over last night for a failure to have his lights on. The officers let him know about this warrant. He came in immediately to take care of it. He's a lifelong resident of the state of Michigan, except for a few years that he left. He owns a restaurant in the city in Eastern Market by the name of Tokoro. He's on top of all this stuff. He hasn't drank in 3 years, Judge. I just want to ask this court to perhaps not impose that alcohol tether requirement. I don't believe that he needs it. I believe a lot of time has passed. There's nothing that indicates that he's going to be at risk drinking and driving.
These are allegations that I do find concerning, is that you previously had a conviction for operating while intoxicated. And then you pick up this allegation, allegedly falling asleep behind the wheel, operating a vehicle while intoxicated. After a previous conviction is concerning regarding the safety of the public. And they were within a 2.5 year period, and which is concerning. These allegations took place in 2022. I'm unaware that you've had any alcohol-related convictions or otherwise. I understand based from the council's representation that you're 3 years sober as of today's date or on or about. And congratulations on that, Mr. President. I know it's going to be a continued struggle, a daily struggle. It's not something that's going to go away. You're going to have to continue to be on top of it and address any concerns. And good luck with your continued sobriety. I do have concerns regarding you operating a vehicle, and your council indicated that you were pulled over yesterday, I believe, and operating a vehicle not alcohol related, and then surrendered yourself to the court, which is appreciated and taken into consideration that you found out about this matter and walked in so quickly to address it. But I have concerns regarding you driving and the consumption of alcohol without any history since 2022, and given your council's representation, I think I can properly protect the safety of the public with a personal bond in the amount of $15,000 personal bond with the following conditions. During this bond and continued, there is no use of alcohol, period. And in lieu of an alcohol tether, I'm going to order no driving at the premises during this period of time. So during this bond, there's no driving of a vehicle while I'm bond. Is that understood?
But the only thing that was, so for the restaurant, like I pick up all of my meats and stuff and like that for the restaurant. So like no driving at all.
What's your opinion? I have concerns as you shared APA, and I think that in lieu of an alcohol tether, I could do it and impose a no driving period. I believe he's employed. He's asked is concerns about that. What's your opinion on a no driving versus alcohol tether?
My opinion as to anything with substance abuse, there's always a potential of recidivism based on it's an addiction. And so I have no objection. If you're going to give driving privileges, then I think he should have an alcohol tether, because his blood alcohol level very high, and it's not that far in the past that 2019 impaired. So, and I appreciate the fact that he is sober and that that's a good thing for him. But at the same point, we have people that fall off the wagon 20 years later. It's just an everyday addiction, as the court has said. So for that reason, I think my opinion is I'm okay with no driving without the alcohol tether. Obviously, then there's no reason for an alcohol tether. But if you're going to allow him to drive for work only, if any time, I'm asking for an alcohol tether, because now we have 2 times that he was caught drinking and driving. And he's obviously presumed innocent on this matter, but based on the allegations, there's a lot of evidence that he may have been drinking and driving from what was said in the IR. Thank you.
Thank you. And that echoes my concerns. And an allegation, what was concerning is you were previously convicted of an alcohol-related offense. Now we have allegations shortly thereafter, within a couple of years, that you're driving, falling asleep while intoxicated, not just intoxicated, extremely intoxicated, over 300% the legal limit. The allegation is your blood alcohol was a 0.268. This was after a conviction for alcohol. We have this allegation, it's just an allegation, but it's a concerning allegation that for you to be alleged to have been on the road with an alcohol content over 300%, causing you to fall asleep while the vehicle was still operating. And so I don't want you operating a vehicle. I have those concerns. I could either fit you with the alcohol tether to ensure that we don't have any alcohol, or I could feel comfortable not putting a tether and then doing a no driving condition while I'm bound.
And Judge,
Counsel, you want to?
yeah, I just had a quick side comment with Mr. Pevich. Obviously, the tether is not an issue. This is not even drinking. He'd much rather be able to drive. Does this court have any ability to impose conditions such as every other day during analysis testing?
I'm going to do a no driving, but continue. I'm inclined to do a no driving, but go ahead.
You're inclined to do a no driving?
Yes.
He would prefer to be on the tether, the alcohol tether, rather than no
He would
driving.
get taken into, you're going to be taken into custody. Did you understand what does he understand that he's going to be taken into custody, sent to the county, wait in the county?
Oh,
until
for
he's
the
fit?
tether?
Yes.
Oh, so he wouldn't get like a 48-hour grace
No.
period for that? Oh, okay, I understand, Judge. Thanks for clarifying that. So then we'll leave your discretion, Judge. Much from there.
All right. So during this bond, it's going to be a $15,000 personal bond, so you don't have to post any money. No alcohol while on bond, and there's going to be no driving. You can address that with the next judge, but at this point in time, I don't want you to drive a vehicle. Okay. Do you have any questions on your court date or bond conditions, sir? All right, and again, good luck with your continued sobriety. I hope it works out well. Officer Brownlee's gonna get you some paperwork. You'll be free to go in a few moments. All right.
Thank you.
Thank you. All right, all right, we're just waiting, on DDC to zoom in.
I'm gonna hop on Zoom, if you don't mind.
Now, Good afternoon. At your pleasure. Good afternoon, Mr. Perkins. How are you?
Very well, Your Honor. How are you?
Well, I'm okay. Thanks for asking. How can I help you?
I've got Christopher Hines, if someone hasn't done him already for my office.
No one has done him, and he's Zoom, and
Yes.
he has not. He's not zoomed in.
Oh, Philip Reagan had said he was on Zoom. Let me text him and tell him.
Wait, maybe somebody from your office just walked in. No, who are you here on, counsel?
You're on Wilkins?
Oh, I'm good, thank you. You're on Wilkins?
Yes, please.
Okay. No Christopher Hines, counsel.
I'll get him on right now.
Okay, and then as soon as we do, we'll handle your matter.
Okay.
And then counsel, good afternoon. Who are you on?
I'm sorry, Judge. Abdul Wilkins.
Okay, let us handle this one at the DDC and then we'll call you as next.
Thank you
okay?
so much, Judge.
You're welcome. DDC, sir, your name, please?
Bernard Sincere.
Bernard what?
No, Purcell, I believe.
Trissell, Andre Trissell?
Yes, sir.
Thank you. Thank you, Ms. Coyle. Mr. Trissell, good afternoon. You're on case 25058-321, People State of Michigan, is Andre Bernard Trissell, also known as Andre Bernard Trissell. Appearances.
Lisa Coyle, appearing on behalf of the people. Good afternoon.
Good afternoon, Ms. Coyle.
Judge Miguel Brico on behalf of Mr. Trissell, my client's been advised of his constitutional rights, waives the form reading the complaint, stands mute, requests that you enter a not guilty plea on his behalf.
Thank you. Good afternoon to you. Court waive formal reading and plea of not guilty. Mr. Trissell, I'm scheduling 2 court dates. You must attend both of them. Probable cause scheduled via Zoom, July the 8th, 8:30, 36th District Court, Judge Taylor. You have a right to a preliminary examination in person, July 15th, 8:30, 36th District Court, Judge Taylor. Understood, Mr. Trissell? Not guilty is entered on your behalf as the bond, Ms. Coyle.
Your Honor, this is non-assaultive, but serious nonetheless. There were 2 stolen guns. He admitted reaching for the gun and it going off, and they found 2 casings in his pocket. But for that matter, Your Honor, people are asking for a $15,000 personal bond with no firearms. Thank you.
Thank you.
No objection to the people's recommendation, Judge.
Thank you. Mr. Trissell, these are serious allegations. I've reviewed the investigator's report. Given the nature of these allegations, lack of capious history, I am going to follow both parties' recommendation. You'll be released on a $15,000 personal bond. You've had previous gun convictions, or you have no right to have a concealed weapon according to your previous conviction, one including being a carrying concealed weapon in an attempt. For those reasons, during this bond, Mr. Trussell, you are not to purchase or possess a firearm or any dangerous weapon. No weapons, understood? Any questions on your court date or bond conditions? You're all set, Mr. Trussell.
Thank you.
Counsel, you're welcome. You ready? One moment. Wait, one moment. Wilkins.
Yeah, it's a capious.
Yeah, we need Chief Judge McConicle on this one. It's a capious matter. Did he post?
Originally it was a personal bond judge, and then it was before Judge Robbins, and then went to Judge Jabri. Certainly there was some miscommunication between the clients, and of course, the court appointed counsel at the time, we reached out to us, we filed a motion to set aside, was assigned to Judge Taylor. Judge Taylor told us to walk in and address it.
Okay, so bond is currently at 20,000 cash or surety. Chief Judge McConicle is gonna zoom in and handle this hearing.
Okay.
Okay, so I'll call him just in a moment. We'll get, thanks,
Yes, please.
thanks for your patience.
Thank you, Judge.
And then, Mr. Vincent, we have, is your understanding, one more capious, Antonio Wells?
I believe so. I believe Ms. Coyle's handling that.
Right,
Yeah.
that one's a Judge Robbins case.
Yeah.
Okay, and that's the only two capious that you're aware of?
Yes.
I'm texting him right now. And then DDC after this one, if we could bring Antonio Wells next. Chief is ready for the capious. Thank you, sir. At the DDC, your name?
Your Honor, I think Wells is in the hospital.
Wells is here.
Oh, is he? Okay, I'm sorry. I'm sorry.
Oh, no worries. Thank you. We'll bring him next, please. At the DDC, your name? What was that? Ronald Lampley Jr. Good afternoon, sir. Mr. Lampley Jr., you're here on case 25058-320, People State of Michigan versus Ronald Terrell Leonard Lampley Jr., also known as Ronald Terrell Lampley, Ronald Lampley Jr., Ronald Therese Leonard Lampley, Ronald Therese Lampley, Ronald Leonard Lampley, Ronald Therese Lampley. Appearance.
Thank you. Steve Vincent, P71917. Good afternoon.
Good afternoon.
Good afternoon. Miguel Brico on behalf of Mr. Lampley. Judge, my client's been advised of his constitutional rights. Waives a formal reading the complaint, stands mute, requests that this court enter a not guilty plea on his behalf.
For a way formal reading and plea of not guilty, Mr. Lampley Jr., I'm scheduling 2 court dates. You must attend both of them. Probable cause scheduled via Zoom, July 1st, Judge Robbins, 36th District Court at 8:30. You have a right to a preliminary examination in person, July 8th, Judge Jefferson, 36th District Court, 8:30. Understood, Mr. Lampley Jr.? Not guilty, please enter on your behalf, Esteban. You're gonna be next,
Magistrate.
okay?
Magistrate, it is a serious matter. You see the way it's being charged. It's a gun offense. I do have prior convictions as well as pleas, but I don't have any prior gun convictions. The only offense that he was previously charged with, it was dismissed. So at this time, we're not going to be objecting to a personal bond. We would be asking for a condition, no guns through the pendency of the case.
Thank you. Response?
No objection. I would recommend you take that off the state's recommendation, Judge, please.
This is a non-assaultive allegation, Mr. Lampley Jr. I'm unaware of any assaultive history or capious. I've reviewed the investigator's report. For those reasons, I'm following both parties' recommendation. You'll be released on a $5,000 personal bond. Given the nature of this allegation, during this bond, you are not to purchase or possess a firearm or any dangerous weapon. No weapons, understood? Any questions on your court dates or bond conditions, Mr. Lampley Jr.? Sure. All right, you're all set. DDC, if we could bring Mr. Wells next, Chief is here ready, and then we have one Capias in person.
Thank you so much, Judge.
You're welcome.
Antonio Gordon Wells.
Thank you, Mr. Wells. One moment, you're going to be next, sir. Just be patient. Thank you. You ready on the Capias, Chief?
Yes.
All right, so we have an in-person matter first we're calling. Sir, state your full name. Thank you. Good afternoon, Mr. Wilkins. This is on case 240578884, People State of Michigan versus Abdul Malik Hussein Wilkins. The allegation is account one, weapons carrying concealed. Capias is 20,000 cash surety, August 8th of 2024 appearances.
Yes, I'm so sorry.
For the people.
Thank you. Chief, as always, it's a pleasure, privilege, and an honor. Steve Benson, P71917.
And good morning, Your Honor, to your staff and important Abdul Wilkins, who appears standing to my right. State your name for this honorable court. Judge, may I please support?
Yes. No, I mean, the
Judge,
prosecutor- I'm sorry. Not guilty plea will be entered in on behalf of your client. As to bond, Mr. Prosecutor.
Judge, actually, I think we're both going to have pretty much the same stuff to say here. There is a failure to appear, albeit one. He was given a $20,000 cash surety. Before he got picked up on that, as you can see, he ended up retaining counsel. The way that I see it in the ROA, there was actually a motion that was filed in front of Judge Taylor requesting this warrant be dismissed or set aside, excuse me. It appears as though he's taken it seriously. Mr. Nasser is involved in this, not showing any favorites, but you know what, when Mr. Nasser gets involved, he tells his clients to show up. So I'm sure they'll show up. If it's a flight issue, the people aren't worried about it. So therefore, at this time, we're not going to object to a personal bond.
All right, Mr. Nasser.
Judge, Mr. Vincent, certainly my client exercised poor judgment back in 2024, Judge. He had originally before Judge Robbins, legal gun, no CPL. That should have been resolved in that particular court. There's a breakdown between him and his attorney, and unfortunately, the communication break caused my client not to understand, not be able to know rather how to communicate with the court and get in. He did reach out to my office, retained myself. We did file a motion to set aside before Judge Taylor. Judge Taylor ultimately brought us into the court here today, Judge. I would ask this court for a personal bond. I can assure you he understands everything. He's here with me. We've been trying to actually get the warrant set aside for about a month or so now. So I respectfully ask this court to instate a personal bond to make himself available, and I'm confident based upon the factual scenario that this will be a quick resolution.
Matt, bond be set at 20,000 personal. Thank you.
Thank you.
Thank you.
Thank
And
you
then
so much.
during this bond, you're not to purchase or possess a firearm or any dangerous weapon. Understood, sir? Your two court dates, probable cause conference via Zoom on July the 1st. You have a right to a preliminary examination, July 8th. Both here at the 36th District Court. Any questions, counsel?
None, Judge. Thank you so much.
You're welcome.
Chief Judge, always a pleasure. Vincent,
Same
thank you.
here. Yes, indeed.
All right, take care.
You got one more, Chief. Sir at the DDC, Mr. Wells, state your full name.
Well,
Thank you. One moment. And then Mr. Wells, this is case 230586490, People State of Michigan versus Antonio Horton Wells. Allegation or the conviction is count one, weapons carrying concealed, failed to appear for a discharge on October 10th, 2024. Bond was set $910 cash. Appearance for the people.
Good afternoon, Judge Lisa Coyle appearing on behalf of the people.
Good afternoon, Magistrate, Chief Magistrate, and Chief Judge. Miguel Abrico on behalf of Mr. Wells. My client's been advised of his constitutional rights, waives a formal reading of the complaint, stands mute, respectfully requests that this court enter a not guilty plea on his behalf.
not guilty plea will be entered on his behalf. Argument.
Your Honor, this is $910. Basically, he went there, he didn't go there for his review date because it's probably unpaid fines. That was back in October of 24. I have no objection since it is a adjudicated matter to converting it to a personal bond. And I would leave it to the court's discretion as to a tether. In this case, I would not be pushing for a tether.
Defense?
Thank you, Ms. Coyle. Judge, I would ask that this court adopt the recommendation by the people of a personal bond conversion. I would ask that you do not put my client on a tether. He was able to show up to court all the way up until that discharge date. It lends to some credence that he knows to show up to court. And that's where I would be at, Judge. I appreciate your consideration.
Bond, court, is gonna reduce the bond to 1,000 personal and not, place a tether on the defendant.
Have a good evening, Chief. Take care,
Thank
sir.
Everybody take care.
Thank you.
Thank you, Chief.
You too.
Mr. Wells, stay put, sir. Stay put, Mr. Wells. I have a few things I need to tell you. All right, so that's a 1,000 personal. During this bond, you are not to purchase or possess a firearm or any dangerous weapon, understood? And then you have a court date, a review scheduled July the 1st, 8:30 via Zoom, Judge Robbins, understood? All right, one moment. All right, Mr. Wells, you also have additional matters with warrants for your arrest for failing to appear at the 36th District Court. On these matters, you'll receive a personal bond, no dollar amount. I'm scheduling a pretrial via Zoom. You must attend July 15th, 9 a.m. Judge King at the 36th District Court, understood? As with any criminal matter, you have a right to remain silent. Anything that you say orally or in writing can and will be used against you in a court of law. You do have the right to an attorney when present at questioning and at all future proceedings. If you cannot afford an attorney, the court will appoint you one at the public's expense. Did you hear and understand your rights? Thank you. This ticket number is SP 1181337. Strike the April 10th, 2021 drive while license suspended. SP 1276523, November 10th, 2021, failed to display valid license not on person. SP 1305410, January 25th, 2022. Count 1, no insurance, a misdemeanor on a 2015 Dodge. Count 2, drive while license suspended. SP 1325841, March 13th, 2022. Count 1, drive while license suspended, a repeat offender. Count 2, drive unregistered untitled motor vehicle. Count 3, no insurance. SP 1383691, August 25th, 2022. Count 1, drive while license suspended. Count 2, no insurance. Misdemeanor on a 2015 Dodge. Count 3, expired plates. SP 1451519, April 20th, 2023. Drive while license suspended. Count 1, count 2, no insurance on a 2015 Dodge. And ticket number 183933694, May 27, 2018, drive while license suspended. Count 1, count 2, unregistered motor vehicle. Count 3, no insurance on an 03 Mercury. During this bond, Mr. Wells, there is to be no driving. Is that understood? These are misdemeanor allegations that carry up to a $500 fine and or 93 days in jail as a maximum fine and penalty. Recall warrant set aside capious enter a not guilty plea. Mr. Wells, as a reminder, sir, released on these matters, personal bond, pretrial via Zoom, July 15th, 9 a.m., Judge King, and no driving. Understood? All right. You got any questions? Nope. If not, you're all set. Zoom user, what's your name? Unmute your device. What's your name? No, it's 1 second at the jail. Sir, on the Zoom, what's your name?
Christopher Hines.
Christopher Hines. All right. Is counsel ready on Mr. Hines? Justin Andrews?
Yes, Your Honor, we are ready on Mr. Hines.
Okay, you're gonna be next, okay? I'll handle
Thank
your
you, sir.
matter just next. Thank you. All right, one moment, Mr. Hines, you'll be next. Sir, at the DDC, your name? John Williams hyphen Sims? Good afternoon, sir. You're here on case 250455526, People State of Michigan versus Job Cleotis William hyphen Sims. Appearance for the people.
Steve Vincent, thank you, Magistrate, Peace 71917.
Thank you.
Judge Miguel Brico, on behalf of Mr. William Sims, my client's been advised of his constitutional rights, waives the formal reading the complaint, stands mute, respectfully requests that this court enter a not guilty plea on his behalf.
Thank you. Court waive formal reading enter plea of not guilty. Mr. William Sims, I'm scheduling a pretrial date via Zoom. You must attend July the 7th, 8:30, 36th District Court, Judge Jones. Understood? Not guilty, please entered on your behalf as the bond, Mr. Wilson.
Magistrate, we're asking for a 5,010% here. This is behavior that is not in line with that of alleged CPL holder. We have an individual who fired a gun after getting into it with his girlfriend, and then threatening her in the manner that was stated in the report. One other thing, Magistrate, we can't forget the idea that, these bullets go somewhere. So if a gun is fired off, it puts everybody at risk in that general vicinity. So I understand it's being charged as a misdemeanor reckless use, but we find this defendant to be a danger. That's why we're asking for the 5,010%.
Thank you. Response.
Judge, I'd have an objection to any amount of monetary bond on behalf of Mr. William Sims. Any amount of monetary bond would be unaffordable for my client, Judge. I understand the state's argument as far as danger to the public. I believe that this court can protect the public through a no contact order with the complaining witnesses, through a no firearms, no weapons prohibition, through the pendency of this case. In addition to that, I don't believe that my client has any history of failures to appear. He indicates to my office no criminal history whatsoever. I do have him working at a temp service location at the moment. He is a high school graduate and a lifelong resident of the state of Michigan, Judge. He has provided us an address in which he lives with his grandma. And this, I'd be asking you, Judge, he's 25 years old. I believe that this stuff will be resolved favorably for him if he just shows up to his court dates and we let people know that during our interview. To assess a monetary bond for the dangerousness argument, I don't see it, Judge. And if you were to assess a monetary bond, I would ask for it to be something reasonable. Any amount would be unreasonable, but within reason, $1,000, 10%. But even then, we would need a redetermination hearing, Judge. That would be my argument to you today.
Thank you both. Mr. William Sims, this is an assault, has assaultive elements. The allegation is you're in possession of a firearm, recklessly waving it in the air, firing off a shot, and threatening to kill the complaining witness. As you're being charged is a 90-day misdemeanor of possession of a firearm, reckless use. No assaultive allegation as far as charges, though, as stated, I had concerns regarding what's in the investigator's report. I'm unaware that you've ever had any history, criminal or capious, assaultive or otherwise. I have the concerns as shared apparently by both parties, and I agree with your counsel. Given your lack of history, this being charged as a 90-day misdemeanor and non-assaultive as charged, the court can properly protect the safety of the public as recommended. Bond will be set, $10,000 personal bond. For the reasons placed on the record, Mr. William Sims, during this bond, you are not to purchase or possess a firearm or any dangerous weapon, no weapons. And you're to have absolutely no contact with the complaining witness, Ms. Smith. That's no contact of any kind. No contact, put your hand down. All right, I'll give you a chance, just give me a moment. No contact orally, in writing, through a third party, at her place of residency, employment, or through any forms of social media. You're to have absolutely no contact with Ms. Smith. Is that understood? Okay, now do you have any questions on your court dates or bond conditions?
Yes, when I got the, when I talked to my mom, the slip was.
Yeah, so Judge, Mr. William Sims, you're okay. Judge, I believe I understand his concern in the incident report.
Yeah, that they live together?
Yeah, it appears to be the same address, correct?
So Mr. William Sims, as I've stated, clearly, you're not to have any contact with her at her residency included. So you're not to go back to that area, the Lauder address at all, nowhere near that area, which is her residency as well, sir. So you're not to go back there. If you go back there, it's a violation of the court's bond, and that's subject to get you picked up just for not listening. So regardless if you're guilty or innocent, you can get locked up just for not listening. That's why I want to be clear. I don't want you to get locked up for just not listening. But if you go anywhere near that area or have any contact with her whatsoever, that's likely to happen. Is that understood? Okay. Do you have any questions on your court date or bond conditions? No weapons, and no firearms, and you have to stay away from Miss Smith. Anything else? Any questions? Anything for people or defense?
No, thank you.
No, thank you, Judge.
Thank you. All right, so are you ready, counsel?
I'm ready, Your Honor.
All right, one moment, DDC, we have one more in person. Just stay right where you are, sir. Thank you. Mr. Hines, good afternoon. Your full name?
Good
Your name, Mr. Hines?
afternoon, Christopher Emmanuel Hines.
Thank you, sir. Good afternoon. This case 25058-288, People State of Michigan versus Christopher Emmanuel Hines, also known as Christopher Hines. Appearance for the people.
Thank you, Magistrate. Good afternoon, Steve Vincent, P 71917.
Good afternoon, Your Honor, to you and your staff. And please, this most honorable court, Justin Andrews, P 81445, standing in for the attorney of record, Attorney Todd Russell Perkins, on behalf of Mr. Christopher Hines, who is present on Zoom.
You say P81445, counsel?
Yes, Your Honor.
Thank you, and good afternoon. Have you you've advised your client of his constitutional rights, is that correct, sir?
Yes, Your Honor.
Thank you. The court will waive formal reading under a plea of not guilty. Mr. Hines, counsel, I'm scheduling 2 court dates. You must attend both. Probable cause via Zoom, July 1st, Tuesday, Judge Robbins, 8:30, 36th District Court. Mr. Hines, you have a right to a preliminary examination in person, July 8th. That's Judge Jefferson, in person, 36th District Court, both at 8:30. Understood, Mr. Hines?
Judge, I will be in South Carolina, and from July 3rd to July 12th, is there any way to reschedule?
Oh, you can talk to your counsel, possibly, but you have to talk to your attorney. They need to reach out to the judge of record at the July 8th date, Judge Jefferson, and they'll have to get permission and the court date changed. But until then, you're not to leave the state of Michigan, Mr. Hines, without permission of the court. And that you have a Zoom hearing July 1st, probable cause or preliminary exam in person July 8th. So if you need to leave on the July 1st date, you need to ask, counsel needs to ask permission from the judge. Is that clear? And
Yes,
as well
sir.
as changing the court date. So on July 1st, you can address those concerns with the court and regarding the July 8th date, okay?
Okay.
Okay. Esteban,
Magistrate,
Yes,
we're
Your
dealing
Honor.
with, whoop, don't worry about it,
Oh,
Mr. Andrews.
no,
I got
apologies.
this. Yeah, no problem. I got it. We're dealing with a writ. It was $500. Mr. Perkins ended up taking care of this. The offense date was on the 21st. He got writted out on the 23rd. 500. We're just gonna ask you to continue this. It's serious, but it's not assault.
response, counsel.
I have no objection to the statement given by my brother counsel.
Okay, so it looks like the writ was posted on or about June 23rd, 2025 of $500 cash. That is going to be continued at request of both parties. Given the nature of this allegation, Mr. Hines, you are not to purchase or possess a firearm or any dangerous weapon while on bond. Is that understood? No weapons.
Yes, sir.
Mr. Hines or counsel, any questions on your court dates or bond conditions, gentlemen?
No, Your Honor, we will seek permission of the Providence Court for Mr. Hines to travel, as you stated, on record.
Thank you. Okay, counsel, thank you, and good luck, counsel, Mr. Andrews and Mr. Hines, you as well.
Thank you, sir. Have a great day to you and your staff.
Thank you, you too. Thank you, DDC. One moment. Appreciate your patience. All right, thank you, sir. Your name, please.
John Colton, Georgia.
Thank you, Mr. Georges. And then DDC, do you know we have 3 add-ons? Streeter, Walker, Triplet, and Cunningham Roberts? Just to let you know. Appreciate you. All right, thank you. All right, good afternoon, Mr. Georges. This case 25058-328, People State of Michigan versus John Colton Georges, also known as John Georges, appearances for the people.
Lisa Coyle, appearing on behalf of the people.
Thank you.
Judge Miguel Brico appearing, I'm sorry, Miguel Brico appearing on behalf of Mr. Georges. My client's been advised of his constitutional rights, waives the formal reading of the complaint, stands mute, requests that this court enter a not guilty plea on his behalf as to all counts.
Thank you. Good afternoon to you. For waive formal reading and plea of not guilty, Mr. Georges, I'm scheduling 2 court dates. You must attend both. Probable cause scheduled via Zoom, July 3rd, 8:30, 36th District Court, Judge Duque. You have a right to a preliminary examination in person, July 10th, 8:30, 36th District Court, Judge Duque. Understood, Mr. Georges? Yes? Thank you. Not guilty plea is entered on your behalf as the bond from the people, Ms. Coyle.
Your Honor, the people are asking for a 25,000 cash surety as well as a tether or an alcohol tether. And for the reason being, this case involves a lot of drinking. In fact, this is at the Temple Bar. Allegedly, the defendant was told to leave a couple times. He did not leave. He began a physical fight. He in fact hit somebody on the right thigh and broke skin of that complainant. Pushed another complainant. There are 4 counts of A and B on this. But the matter at hand is regarding the female here, Ms. Shop, in which he blamed her for breaking his glasses. Obviously very intoxicated. He grabbed her, allegedly shoved her, and she fell to the ground. And while she was on the ground, he was hitting her head more than once against the concrete while he's on top of her. Now, he's a male, she's a female. Bystanders had to pull him off the complainant. She suffered a mild concussion, multiple bruises about the body, bruising around her neck, swollen ear, abrasions to her ear, bruising and abrasions to her face, both knees and both elbows. He is also got a prior 2019 operating while impaired. He's also got a prior domestic violence, 2014. And I do see under 2011, a possession of marijuana and a weapon in a school zone under height of status. Your Honor, this occurs at 1 o'clock in the morning at the Temple Bar. He's, like I said, he's very intoxicated. You can see him. He's got a black eye. So it took several men to try to stop him. He was insistent on getting into that bar. And so for this reason, Your Honor, he's not only dangerous to the complainant in this matter, but he's danger to the community because it appears that, and I'm hoping that it's just alcohol got to the best of him, but this is a recurring issue, 2019 impaired and a 2014 domestic violence. So I'm asking for that cash surety bond as well as the court discretion. I'm asking for an alcohol tether or a tether house arrest, Your Honor, based on the severity of what he did to this young woman.
Thank you. Response.
Judge Miguel Brico on behalf of Mr. Georges. Judge, I definitely understand the people's position. I understand this court's obligation in determining if my client is either a flight risk or if he's a danger to anybody in the public. I don't believe that this is a flight risk argument, so I'll just continue forth with any danger to the public. Judge, I object to any amount of monetary bond on my client's behalf. Any amount of monetary bond would be unaffordable for my client. I do see that the initial allegations stem from incident between my client and a related party. I do believe that a no contact order would suffice in protecting that unrelated party. I do see that the charges themselves, as they are charged, indicates this is a very serious offense, and that's why they were charged that way. But I do believe we put a no contact order between him and the main complaining witness, and as well as all the other complaining witnesses being unrelated parties, then they are sufficiently protected. I do understand his prior 2014 domestic violence dating back over 10 years, and I would ask this court to not put too much weight onto that 10-year prior. I also do have my client working at WG Heating and Cooling. I do have a good address for him in the state of Michigan, in which he's been a lifelong resident. I do have the main complaining witness at that same address, Judge, and my office has neglected to ask Mr. Georges if he has an alternative address. So upon the completion of my argument, I'll ask him that on the record. We have no objection to any alcohol monetization, no objection to any physical monetization, no objection to anything more so than the amount of monetary bond being imposed, Judge. That's my argument for you today. Thank you.
Thank you both.
I took this as a boyfriend-girlfriend situation. I'm sorry, is that correct, Mr. Rico? I didn't.
It is. I believe I'm just going based off of they added more complainants, and I believe those may just be the other people that were present at the bar of the night in question.
Okay.
Thank you both, and that's how I read it. Yeah, Mr. Georges, this is a very serious assaultive allegation that seems to have escalated, and that's where I have concerns. This was an escalation. Coupled with your criminal history, you have a previous conviction for domestic violence, bringing us to a second offense notice. Now we have allegation of an extended an assault on an individual that you apparently were in a dating relationship residing with. And then extended based on an argument apparently where you alleged to have spit in her face. You struck the complaining witness, and then back at the residence, apparently there was a little time that appeared to have passed. And it's as the allegations continue of assault, where it's alleged that upon getting in another argument, you produced a handgun, began waving it at this young woman, threatening to kill the complaining witness, firing a shot in the air in the city of Detroit, where I do find a likelihood of conviction on a number of things. A spent shell casing was recovered in a driveway, according to the investigator's report. As you've heard from the people, this complaining witness suffered a number of injuries. And that's all not only leads towards a likelihood of conviction, but it's also highly concerning to the court regarding her safety. And that's given coupled with your criminal your convictions in past, one of them being a domestic violence. And so here, Mr. One moment. I apologize. One moment. Some of that information, this was on that's on a separate
Judge, I was
investigator's report that was included. Yeah, thank you both. I should speak up. So that was included in a separate two files apparently now have been combined together. So strike a lot of those arguments and conditions, Mr. George. One moment, please. They had the files mixed up. Okay, thank you both. I apologize about that, Mr. George. So a separate file was included. So we'll start back from the top, and I appreciate both arguments for counsels. So Mr. George is on this matter. The history, you do have it is all accurate. You have a previous domestic violence related conviction, and that's also concerning. Here is the allegations as stated by the people is that you were observed attempting to enter this Temple bar, apparently highly intoxicated, according to the investigator's report, where you were observed assaulting this young woman and a number of other individuals. It's alleged, amongst other things, that you were observed forcefully shoving one of the complainants, then forcefully shoving the complainant's head into the concrete, where she was observed to have abrasions and a head injury. It's further alleged that after you smashed her head into the concrete, body slammed her onto the ground. When she attempted to get up, you smashed her head into the concrete again. And she's stated that she felt like she was going to lose consciousness. There are, as stated by the people, a number of injuries that were alleged to have observed, treatment that she had to receive at Cornell Health Hospital in Troy, injuries to her neck, swollen right ear, abrasions throughout her body, bruising. And for those reasons, given that the court finds a high likelihood of conviction, this, as stated, was an escalation of assaults on this young lady, where you've previously had a domestic violence conviction. And in order to set an unaffordable cash bond, the court does find here by clear and convincing evidence, given the extent of this prolonged assault on this young woman, as well as allegations of assaulting other individuals that are attempting to intervene, you are a danger to this complaining witness, and finds by clear and convincing evidence you are a danger, and a personal bond will not adequately protect her safety. So the bond is being set as recommended by the people, $25,000 cash or surety, to properly protect, and given the allegations of intoxication and stated in the record, during this bond, you are not to use any alcohol, period. You're not to purchase or possess a firearm or any dangerous weapon. You're not to go anywhere near the area or premises of the Temple Bar in Detroit, Michigan. You're to have absolutely no contact with any of the complaining witness, including Alexis Smith, Amy Shope, Eric Loss, James Copeland, Mason Sultana, and Raleigh Christie. No contact with any of those individuals is no contact of any kind, orally in writing, through a third party at their place of residency, employment, or through any forms of social media. And to properly protect their safety, you will be fit with a GPS tether prior to being released, and that will place you under a curfew of 10 p.m. to 6 a.m. During those hours, you're not to leave for any reason unless court ordered or medical. If you go anywhere near that location or any of those complaining witness, that's a violation of this court's bond, subject to get you picked up without a warrant, have your bond conditions forfeited and or revoked. Do you have any questions on your court date or your bond conditions, Mr. George? And that's unaffordable, counsel?
Yes, it is.
All right, Mr. Georges, I'm scheduling an unaffordable bond redetermination hearing 2 days from today in front of Chief Judge McConico on June 26th via Zoom at 9 a.m. If you cannot afford that bond, you'll see the chief judge and you'll have a defense counsel present and an opportunity to re-argue bond at that point. Do you have any questions on your court dates or your bond conditions?
I need $25,000 or I can't be let go.
25,000 cash or surety. Yes, and if you're unable to post that, you'll see the chief judge in 2 days and have an opportunity to re-argue the bond. And if you are able to post, you'll be with those restrictions that I've stated on the record. Are you any other questions on your court date or your bond conditions?
The July 3rd and then July 10th.
Yes, thanks for paying attention. Those two you'll always have to attend. And then 2 days from today, June 26th, only if you're still incarcerated and you're unable to post that bond. Any other questions? People or defense, anything further?
Nothing further, thank you.
You're welcome.
Mr.
Defense,
Benson
anything
is
further?
the waiting room.
Oh, thank you. Anything further, defense?
Oh, no, Judge, thank you.
Okay, thank you, bro. Side by side, I think. Three. This is correct. Let's see. All right, are these, your names?
Yeah.
Okay, I couldn't hear any of you, I apologize. Is this Mr. Streeter? That's in the middle? Okay, one moment, everybody. Do you want to call these all together, defense, or separately?
Judge, I'll leave it at your discretion. I don't mind either way procedurally.
One of these. What do you want to do, Mr. Vincent? Call them together?
Yeah, let's do them together.
Any objection from defense?
No, Judge.
Okay. One moment. All right, so we got Mr. Streeter, Mr. Walker Triplett Jr. Okay. And then Mr. Cunningham Roberts. Okay, one moment, gentlemen. All right, this is case 250-58333, People State of Michigan versus Jeremiah Cortez Streeter, identifying the complaints defendant 1, also known as Jeremiah Streeter, James Elwood Walker Triplett Jr., identifying the complaints defendant 2, also known as James Elwood Walker Triplett, James Walker Triplett, James Elwood Walker Triplett, Michael Amarian Cunningham Roberts, identifying the complaints defendant 3, also known as Michael Amarian Cunningham Roberts. Appearance for the people.
All three matters, Steve Benson, P 71917.
Thank you.
Judge Miguel Perico, on behalf of all three of my clients that are here today on the screen, Mr. Roberts Cunningham, Mr. Walker Triplett, and Mr. Streeter, as well to all three cases. Judge, all of my clients in regards to their respective cases have been informed of their constitutional rights. They waived the reading of their complaint, the formal reading of their complaint, and they all stand mute and request that you enter a not guilty plea on each three of their behalves as to all counts.
Thank you both. Gentlemen, the court waive formal reading and enter plea of not guilty. All three of you have the same court date and times. All three of you have a probable cause conference scheduled July 8, 8:30 via Zoom, Judge Taylor, 36th District Court. All three of you have a right to a preliminary examination July 14th. That's in person, 8:30, 36th District Court, Judge Taylor. Did you hear and understand those court date and times you must attend, Mr. Streeter? Did you hear and understand, Mr. Walker Triplett and Mr. Cunningham Roberts? Okay, not guilty, please entered on behalf of all of you as to bond from the people.
Magistrate, on all three of these individuals, we're going to be asking for a remand under MCR 6.106B1B. It's available to us because all three defendants are charged with the armed robbery. They're also all charged with the carjacking. That wouldn't qualify for the remand. However, the armed robbery does. In addition, all three defendants are charged with 2 counts of felony firearm and 1 count of RCSP motor vehicles. This was planned. These defendants planned to carjack their friend, and they did it at gunpoint, and then they ended up stealing his belongings. Ironically, all three of these defendants don't have licenses. They've either been revoked, they're not licensed, or they're suspended. And we have these defendants planning a carjacking. In addition, Magistrate, I have Mr. Walker Triplett to be on probation right now for a CCW. He got 2 years probation, December of 2023. Magistrate, the community is not safe with these individuals in it, at least through the pendency of this action. They're all facing 2 life counts here. Respectfully, we're asking for the remand under the statute.
Thank you. Response.
Judge, on behalf of all three of my clients, and forgive me for belaboring some of my points today, since I do need to pay respect to each one of my clients' individual situations in life, I'd be asking this court to impose a reasonable amount of bond on this matter so that my clients, because any amount of monetary bond would be unaffordable, would at least have the opportunity of going in front of the chief judge of this court and having an opportunity to have that bond lowered or have a starting point to understanding that they may be able to exit pretrial detention at some point in time. Judge, beginning with Mr. Walker Triplett first, I do want to touch base a little bit on his life. He's a lifelong resident of the state of Michigan. I do understand the severity of the charges. He does work. He works at Kroger. As you can see currently on the screen, my client is being held up by one of the other Codys. And Judge, that's because he was shot in the spine. Cannot go to the bathroom at the moment. He indicated to me an urgent need to attend the hospital. At the end of my argument, I will indicate for you to request a DDC mark of as medical. He needs to go to a hospital immediately. He's been shot in the spine, Judge. He does have a good address in the city of Detroit that he's provided us. He lives at home with mom and has 2 children. On behalf of Mr. Streeter, Judge, also a lifelong resident of the state of Michigan, has provided us an accurate address in which he lives with his aunt. He has 1 child. All of my clients, Judge, are between the ages of 21 and 25. Are very young. I have 1 client at 21, 1 at 23, 1 at 24, all very young that are in front of us today, Judge. Mr. Streeter does work as a school janitor. He indicates to my office he has no prior assaultive history and no pending cases, probation, or parole due to that fact. And Judge, lastly, but not least, on behalf of Mr. Roberts Cunningham, my client is also lifelong resident of the state of Michigan, indicates to me no prior criminal history, no pending cases, probation, works at McDonald's, providing me an address in which he lives at home in the city with his mother. Judge, I understand these cases are very, very serious. They are all allegations. All my clients are presumed innocent unless proven guilty beyond a reasonable doubt. At this very moment, we are observing an innocent group of men. And I would ask you, Judge, to give them that and afford them that right and allow them to have some type of reasonable bond as a starting point for us to work from. I would object vehemently to any amount or to any remand, Judge. I just believe that the remand of this situation will remain. This will be a long, drawn-out process. My clients will be in pretrial detention for the entire time. They're very young. They all stay in the city. I don't have any reason to believe that they're flight risk. I understand the dangerousness argument here. The complaining witness appears to be a related individual to my clients. So I believe that this isn't a general danger to the general public. I do understand your need to protect the specific complaining witness. I would ask for you to do that through other means, Judge, and please allow them some amount of bond to work with today. Thank you. That is my argument. And as I stated prior, please, DDC, if they may, mark Mr. Walker Triplett as an urgent medical need. And that's where I would be at, Judge. Thank you.
Thank you. Please mark Mr. Walker Triplett's file medical, DDC, for the reasons stated by counsel. Thank you. Thank you. And Mr. Walker Triplett, he's on probation currently, correct, Mr. Benson?
Correct.
Thank you. These are very serious allegations, specifically counts 1 and count 2, both possibility of life offenses. Criminal history, I'm unaware of Mr. Streeter, Mr. Cunningham, Mr. Walker Triplett, as stated by the people, very concerning. You're currently on probation while you picked up these allegations, extremely serious allegations. After I've reviewed the investigator's report, and this does appear to be planned, and according to admissions, one of your own admissions, it's alleged in the investigative report that you planned this attack to carjack the complaining witness, where one of the individuals stated they had a loaded firearm with him, and the planning was to leave and carjack this individual, which apparently took place. And according to the investigative report, where you three approached the complaining witness, put a gun to his back, and then began to go empty his pockets, took his vehicle, and then fled the location. As I stated, there's not only just apparently a planned attack according to your own admissions, but I also find a likelihood of conviction, not only based on your own admissions, but based on the complaining witness having positively identified all 3 of you out of a photo lineup. And so here, Mr. Walker Triplett, the court has concerns regarding your probation and status, but given the likelihood of conviction, the court finds that guilt is evident, presumption of guilt is great. I do find all 3 of you to be a danger to the community. These are extremely serious allegations, the serious offenses. And for those reasons, finding you all to be a danger to the community, guilt being evident, presumption of guilt being great, I am going to remand all 3 of you into custody for further proceedings. Mr. Walker Triplett, do you have any questions on your court date or bond conditions? And during this bond, 1 second, no contact with the complaining witness, Mr. Abbott, no contact of any kind, orally in writing through a third party at his place of residency, employment, or through any forms of social media. No contact. So Mr. Walker Triplett, do you have any questions on your court dates or bond conditions? I can't walk, I can't run. What, do you have a question?
I'm really so concerned. I can't really, it's kind of, I had told my attorney, but I'm not here like, I can't use the bathroom. The same. I was just trying to see that
But I hope you get the medical assistance immediately that you need. We marked your file medical. I hope that you are feeling better and get the assistance as quick as possible. But do you have any questions on your court date or your bond conditions regarding this matter? Your bond on all 3 of you is a remand. That means that you don't have a bond. You're going to be held into custody for further proceedings. I'm denying you all bond at this point for the reasons placed on the record. And during this bond, you're going to have any contact with the complaining witness. Is that understood? And do you have any questions, Mr. Walker Triplett? Mr. Streeter, do you have any questions? Go ahead. Questions on your court date or bond conditions, Mr. Streeter? You're on mute. I can't hear him. What's your question, Mr. Streeter? Go ahead. Yes. No. Your next court date? all three of you have the same two court dates I'm scheduling. Probable cause via Zoom on July the 8th. That's a Tuesday. Judge Taylor, that'll be at 8:30. Then all three of you have a right to a preliminary examination in person, July 14th, the following Monday, all in front of Judge Taylor, 8:30. July 8th, July 14th. Any other questions on your court dates or bond conditions, Mr. Streeter?
Yeah, I was figuring out, this is my first event, so I was wondering like, why was
Judge, may I? Mr. Streeter,
Yes.
this is your attorney speaking. Listen, the judge has already imposed his bond. I understand you're confused on why. You're gonna have another attorney at your next court date on the 8th, in which you can discuss and possibly retry to get some type of bond where you can pay to get out. But right now, nothing's gonna change the judge's mind. And in fact, I'd prefer if all three of you do not say anything more today unless it's about your court dates or your bond conditions. And don't make any statements in the jail. Don't talk on the jail phone. Don't talk with any detectives without a lawyer present, please. Thank you,
With
guys.
that advice from your counsel, Mr. Streeter, do you have any questions on your court date or your bond conditions, sir? No? Mr. Cunningham Roberts, do you have any questions on your court date or bond conditions? If without questions, all three of you are all set.
Great.
Claudia,
Yes.
you handed me that Blake. Who's that? You said it was a three-bagger, but it's not. Is that three-bagger that you denied? I don't know.
Ask me the in person.
Yeah. Oh, was that Hill Bond?
Who you're in? Oh, yeah, you have to walk in. She gets-
Number 11.
And then lock.
And unlock it. Is there any other mails?
Yeah. No.
What do I have over there? Anything over there? So is that all the mails, DDC? Is that all the mails, DDC? Is that all the mails?
It's on the mail, Judge, and then on the walk-in Hill van, we made contact and then we can't find the contact.
Okay.
Find anymore.
Jasmine, yeah.
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 Okay. Sorry about that.
No worries. Good afternoon, ma'am. State your name, please. Jalise Sherrod.
Delisha Sharad.
Jalisa. Good afternoon.
Good afternoon.
Apologize. Thank you. All right, Ms. Sherrod, you're here for a couple of reasons. We're going to go through them one at a time. First, you have a number of warrants for your arrest for failing to appear at the 36th District Court. On these matters, you'll be released on a personal bond, no dollar amount, and scheduling a pretrial date via Zoom you must attend on July the 10th at 9 a.m., 36th District Court, Judge Archer. Understood?
Yes.
Thank you, Mr. Sherrod. As with any criminal matter, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in the court of law. You do have the right to an attorney, one present at questioning and at all future proceedings. If you cannot afford an attorney, the court will appoint you one at the public's expense. Did you hear and understand your rights?
Yes.
These are on ticket numbers SP 1406202, November 19th, 2022. Count 1, drivable license suspended. Count 2, unregistered, drive unregistered, untitled motor vehicle. Count 3, no insurance on the 2013 Chevy SP 1122420, October 16th, 2020. Count 1, drive unregistered, untitled motor vehicle. Count 2, no insurance, misdemeanor on a 2013 Dodge. Count 3, failed to display valid driver's license. SP 1122743, October 12th, 2020. Count 1, drive unregistered, untitled motor vehicle. Count 2, no insurance, misdemeanor on a 2013 Dodge. Count 3, drive while license suspended. SP 1141308, January 31st, 2021, drive while license suspended, repeat offender. SP 1177326, March 22nd, 2021, drive while license suspended. Count 1, count 2, open alcohol in a motor vehicle as a driver. SP 1258748, October the 4th, 2021. Count 1, drive while license not valid or improper license. Count 2, drive unregistered, untitled motor vehicle. Count 3, no insurance, misdemeanor on a 2013 Dodge. SP 1258946, October the 2nd, 2021, improper plates. Count 1, count 2, no insurance, misdemeanor. Count 3, drive while license suspended. SP 1259213, October 5th, 2021. Count 1, drive unregistered or untitled motor vehicle. Count 2, no insurance, misdemeanor on 2013 Dodge. Count 3, drive with revoked license. SP 1317057, February 20th, 2022. Count 1, drive with revoked license. Count 2, no insurance, misdemeanor on 2013 Dodge. SP 1322862, March 4th, 2022. Count 1, failed to display valid driver's license not on person. Count 2, no insurance, misdemeanor, 2013 Dodge. SP 1326865, March 10th, 2022. Count 1, drive while license not valid or improper license. Count 2, drive unregistered, untitled motor vehicle. SP 1347232, April 29th, 2022. Drive with revoked license. You're not to drive any vehicle while on bond. No driving. Is that understood?
Yes.
Thank you. SP 1358790, June 1st, 2022. Count 1, drive unregistered, untitled motor vehicle. Count 2, no insurance on the 2013 Dodge. Count 3, drive while license not valid or improper license. SP 1364663, June 17th, 2022. Count 1, drive with revoked license. Count 2, no insurance, misdemeanor on 2013 Dodge. Count 3, drive unregistered, untitled motor vehicle. Ticket number SP 1369604, July 3rd, 2022, drive unregistered, untitled motor vehicle. Count 1, count 2, drive while unlicensed. SP 1530550, December 10th, 2023. Count 1, driver's license never required. Count 2, no insurance, misdemeanor, 2013 Dodge or Chevy. Count 3, drive unregistered, untitled motor vehicle. And ticket number SP 1583117, June 9th, 2024, drive while license suspended, repeat offender. These are all misdemeanor allegations. They carry up to a $500 fine and or 93 days in jail as a maximum fine and penalty. Recall those warrants, set aside capias, enter a not guilty plea on each open matter. As a reminder, no driving, Ms. Sherrod, and you'll have a personal bond. You must show up for your pretrial via Zoom, July 10th, 9 a.m., Judge Archer. Understood? State your full name again. You have an additional case.
I'm sorry,
State your full name again. You have an additional matter.
Delisha Sharad.
This is case number 2505839, People State of Michigan versus Jalisa Patrice Sherrod, appearance for the people.
Thank you, Steve Benson, P 71917.
Judge Miguel Brico on behalf of Ms. Sherrod. My client's been advised of her constitutional rights, waives upon reading the complaint, stands mute. Respectfully request that this court enter a not guilty plea on her behalf as supervised.
Thank you both. Court waive formal reading under plea of not guilty. Ms. Sherrod, I'm scheduling 2 court dates on these matters. You must attend both of them. Probable cause via Zoom, July the 3rd. That's a Thursday, 8:30, 36th District Court, Judge Jakay. You have a right to a preliminary examination in person, July 10th. That's at 8:30, 36th District Court, Judge Jakay. July 3rd, July 10th. Understood?
Yeah.
Not guilty, please enter on your behalf. Waive formal reading. That's the bond, Mr. Vincent.
Magistrate, we're asking for a 10,000 cash or surety. We're asking for a tether as well as a curfew. It's highly assaultive, but it's also highly destructive. In addition to that, allegedly what this defendant ended up doing caused the complainant to go to the hospital and receive 3 stitches as a result of that assault. Magistrate, it recently occurred, so we find this defendant to be a danger to the complainant at this time, and respectfully, we're asking for the cash with the monitorization.
Thank you. Response.
Judge, on behalf of Mr. Rod, I would object to any amount of monetary bond. It would be unaffordable for my client. Judge, looking at the incident report itself, it appears second to last line that the defendant drove to the 11th precinct where she attempted to make a police report with the desk officer. This relates a little bit to what our client had told us during interview, which obviously there's 2 sides to this story. And today I'm not going to speak her whole entire side, but I do just want to, pay a little bit of credence to that fact, Judge. As far as monetization requirements, I don't have a specific objection to that. I understand that you have the obligation to keep the public safe. I think a no contact order would suffice with that complaining witness, as well as any other monetization requirement. I would be asking you to not impose any amount of monetary bond. My client is unemployed. She indicates in my office an address where I presume she can receive mail at, but that she is homeless, Judge. So any amount of bond that you're going to impose is going to be a pretrial detention for my client. That's my argument, and I would leave it at your discretion for the rest.
Thank you both. And I think you said, Mr. Vincent, no assault of history you're aware of, correct?
No, I didn't. Exactly.
Said so much without saying is what I meant to say. So Ms. Sherrod, these are assaultive allegations, and I have concerns regarding the safety of the complaining witness, as these allegations seem to have escalated to a point that you allege to have produced a cutting instrument, swinged at the complainant, cutting the complaining witness a number of places throughout his body, and then fleeing the location. Further alleged that the complaining witness had to go to Henry Ford Hospital receiving stitches to his chin and bandages to other areas that you allege to have sliced him with a cutting instrument. The court here giving the allegations, the extent of injury, the escalation from apparently what took place to you producing this, allegedly producing this cutting instrument, swinging it multiple times and then fleeing the location. Those are all concerning to the court regarding the safety of this complaining witness. And now, given your lack of history or capious history, I am going to set bond in part recommended by both parties. You're going to be released on this matter on a $20,000 personal bond. You don't have to post any money, Ms. Sherrod. You'll be released. But given the concerns I placed on the record and the allegations of extent of injury, given the concerns regarding the safety of the complaining witness, before you're released, you will be fit with a GPS tether, and I'll place you under a curfew of 10 p.m. to 6 a.m. During those hours, you're not to leave your home for any reason unless court ordered or medical. Also, during this bond, given the allegations placed on the record, you're not to purchase or possess a firearm or any dangerous weapon. No weapons. You're not to go anywhere near the England Street address in Detroit, Michigan. Stay completely away from that area and premises. And no contact with the complaining witness, Mr. Jenkins, of any kind. No contact orally in writing through a third party at his place of residency, employment, or through any forms of social media. No contact with the complaining witness. If you violate and have contact with that area or that gentleman in any form or fashion, you will be monitored via a tether, and that would subject to get you picked up without a warrant and have your bond conditions forfeited and or revoked. Do you have any questions on your court date or your bond conditions?
Yes, I do. We have a
What's your
child,
question?
and I would like to retrieve my child from him so I can go on and not contact him. My dad indicated that he would try, or if it was okay to contact his mom, and then my dad and his mom could exchange our child, and then I have no reason to contact him at all.
You're not to have any contact with Mr. Jenkins Counsel, is there a court order in effect for the child custody counsel? She's saying no.
Judge, I was wondering the same. No. So Ms. Sharada, I understand your point and I get what you're saying. The judge has ordered you to have no contact. And I do know that you guys have a child in common. If there's no custody order that you can follow in regards to that, I will ask the judge today on the record and see what he thinks if you're able to use a third party to do that exchange. Judge, would that be something that you would allow for a third party to do custody exchange?
I'm not gonna get into like child custody and exchanges. That we're here for a criminal matter. What I'm ordering her is no contact. I don't know anything about her family situation. What I do know is I find her to be a danger with this complaining witness. So I want her to have absolutely no contact with this complaining witness while I'm bond.
Understood. Thank you, Judge. And Mr. Rod, you need to understand that that means if you instruct someone else to contact him for the retrieval of your child, that would be considered contact. So please don't violate that.
Can I work with a friend of?
But that is completely within your discretion. You may take that avenue up, but we're in a criminal court today on a criminal charge. So that's up to you on that end.
No, I'm asking would that be an obligation to go to the friend of the court and go through that?
I have no counsel, just to answer your question, I'm gonna cut in, but I can give her no conditions about going to the front of the court if she wants to take that avenue. Within curfew, you do have a tether and a curfew, but as long as you abide by the court conditions, I have no problem with anything else you do. You just have to follow my orders. And I didn't say anything about front of the court. Anything further, Ms. Sherrod? Any questions on your court date or your bond conditions?
If you can tell it before I leave.
Yes, GPS tether before you leave. Any other questions on your court date or your bond conditions?
Does that cost money?
Counsel?
Judge, to be candid, I don't know if that costs money. It's my impression that if it's a pre-trial matter, that they don't pay for it. It's only during probation.
Yeah, you're right. And they'll explain all to you at the tether. Yeah, but they'll explain all of that to you at the tether unit when they fit you. Any other questions, Ms. Sherrod?
No.
People or defense, anything further?
No.
No, Judge, thank you.
All right, you're welcome. You're all set, man. Your name, please?
Arian Boswell.
Good afternoon, Ms. Boswell. Ms. Boswell has two matters. First, we're gonna call some matters. You have warrants for your arrest, and we have additional matters. So, Ms. Boswell, we're gonna handle everything. First, the matters we have warrants for your arrest, and we'll get to your criminal matters. Handle misdemeanors first. So on these matters, Ms. Boswell, I'm going to release you on a personal bond, no dollar amount, scheduling a pretrial date via Zoom. You must attend on July 9th, Judge Yancey at the 36th District Court. Understood? Ms. Boswell, as with any criminal matter, you have a right to remain silent. Anything that you say orally or in writing can and will be used against you in the court of law. You have the right to an attorney, one present at questioning and at all future proceedings. If you cannot afford an attorney, the court will appoint you one at the public's expense. Did you hear and understand your rights?
Okay.
Ms. Boswell, this in regard to ticket numbers SP 1486972, August 10th, 2023. Count 1, driver's license never acquired. Count 2, drive unregistered or untitled motor vehicle, and SP 1702834, March 28, 2025. Count 1, drive unregistered untitled motor vehicle. Count 2, no insurance misdemeanor on 2016 Chevy. Count 3, drive while license not valid or improper license. These are all misdemeanors that carry up to a $500 fine and or 93 days in jail as a maximum fine and penalty. Recall your warrant, set aside case, enter a not guilty plea on your behalf. You'll be released personal bond pretrial via Zoom July 9th, 9 a.m. Judge Yancey. Ms. Boswell, you have two additional matters. Any objection calling them together from the people?
No, Your Honor, thank you.
Any objection calling them together from defense?
No, Judge, thank you.
Okay, Ms. Boswell, do you have a question?
No, I'm sorry.
Okay, so pay attention to the court, please. It's important what we're doing. So you have two additional matters. We're going to call them together without objection. So state your name again.
Arian Boswell.
These are both on case numbers 25058-326. People state of Michigan, Zaria Kalilia Boswell, also known as Zaria Boswell, Zaria K. Boswell. And case number 25058-327. People state of Michigan, Zaria Kalilia Boswell, also known as Zaria Boswell, Zaria K. Boswell. Appearance for the people.
Keith Coyle appearing on behalf of the people.
Judge Miguel Brico, appearing on behalf of Ms. Boswell. My client's been advised of her constitutional rights, waives the formal reading the complaint, stands mute, respectfully requests that this court enter a not guilty plea on her behalf as to all cases.
Thank you, both of you. Ms. Boswell, the court waive formal reading and her plea of not guilty. On both of these cases, I'm scheduling the same court date and times. You'll have a probable cause conference via Zoom, July the 3rd, 8:30, 36th District Court, Judge Jakay. You have a right to a preliminary examination in person, July 9th, 8:30, 36th District Court, Judge Jakay. Did you hear and understand those two court date and times you must attend? Yes, thank you. Not guilty, please entered on your behalf as the bond from the people.
Your Honor, people are recommending a 50,000 cash surety. She's able to make that bond. I'm asking for a tether house arrest. I'm also asking for no driving in this matter. I'm going to start with the offense that occurred.
Is that, I don't mean to cut you off. Is that on both of them? The same recommendation for each?
Yes. Yes, and for the following reasons. On April 12th of 25, we have the same complaint in Mr. Carson on both matters. He has child in common with Ms. Boswell. Those allegations are that she went through his cell phone, she became angry, broke a window, he went out to look, attempted to hit the complainant several times with her car. Then on the allegations as to June 22nd, she called him, said, "You want me to come over," and caused a scene. Then she came over and with her vehicle, accelerated his car in his direction, struck him in the legs, and he landed on her car hood. Per the allegations, she attempted to hit him several other times with her car. She then pulls onto the grass and sounds her horn. And then at some point later, she returns and attempts to hit him, and she struck the building. It is also to note that she pled guilty on March 27th of 24 to felonious assault. She's under HIDTA status. She has a violation. She had a violation on that matter about 2 months later on the 20th of May of 24. She received 2 years probation for that felonious assault. When I looked into that felonious assault, it's a completely different complainant. And in that matter, she attempts to hit hits the complainant who is in on the passenger side of the car and hits her standing next to her car. And so
with her car?
Pardon?
She hit her with her car?
Yes. That's
the conviction? Okay.
That is what she pled guilty to, the felonious assault. She then is on probation for 2 years. So because it's HIDTA, I can't look and see if she's still currently or her probation was ended. But it is apparent from these matters, Your Honor, there's a similar theme in that she uses her car as a weapon. And I'm going to go back to that question you asked me. The complainant is standing in the rear passenger door jamb of the vehicle. As the defendant's vehicle approaches, defendant strikes the vehicle in the passenger door that was open at the time at a high rate of speed, causing the complainant to be smashed between the car door and the body of the car itself. She then continues to drive off at a high rate of speed, fleeing the scene of the crime. So that's from the IR of the case she pled on. So I do believe, based on this, Your Honor, this is a completely separate person, and she's on probation for the same thing. And then now we have 2 allegations within 2 months of each other that she's using her car to allegedly strike Mr. Carson. And he's also a young man. He's, I believe, 20 years old himself. So based on those allegations, Your Honor, I'm asking for that 50,000 cash surety, tether house arrest, no driving, no contact. Thank you.
Thank you. Response.
Judge, on behalf of Ms. Boswell, please consider my argument as to both cases. I understand all the charges alleged against my client, Judge. I understand this court's obligation to the public and keeping them safe, specifically this complaining witness. Judge, I would be asking you to consider a personal bond on the matter. My client is very young. She's only 20 years old. Perhaps in her later years, she'll become more and more wise. But at this very moment on which she's charged with, Judge, she is presumed innocent and will remain that way unless proven guilty beyond a reasonable doubt. She does have 2 children in which she takes care of. She does not work. She's a stay-at-home mother. She's the sole caretaker for her children. I understand the state's recitation on any prior cases or probation that my client may be on. I would ask this court to take into. I'm also asking you to consider type of conditions that you may be able to